Hello and welcome to A Seat at the Sitting for March 2025. I'm Nate Kazmarek, Vice President and Director of the Practice Groups. This afternoon, March Madness is upon us. I can honestly say we've gathered all number one seeds in terms of our presenters today. Our excellent panel will preview the upcoming oral arguments before the court, and then our experts will take questions from the audience. Our aim is to get through it all in 90 minutes or less. As you know by now, the Federal Society doesn't take any positions, and all views expressed during this webinar belong to our speakers. I am thrilled to welcome a great moderator today in Sarah Welch. Thank you, Sarah, for taking the time. How are you this afternoon?
Doing great. Glad to be here, Nate. Thanks for the invite.
Definitely pleased to have you with us. Sarah was most recently an associate at Jones Day, but very soon she'll be starting as counsel in the Department of Justice's Civil Division. So congrats on the new gig, Sarah. Before joining Jones Day, she clerked for Justice Kavanaugh on the Supreme Court, Judge Bill Pryor of the U.S. Court of Appeals for the 11th Circuit, and Judge Jeff Sutton of the U.S. Court of Appeals for the 6th Circuit. Her law degree is from the University of Chicago, and her undergrad is from Ohio University. Full bios for Sarah and our entire panel are available for your review on our website, fedsoc.org. This panel will cover the upcoming cases, then we'll go to audience Q&A. So please start thinking about your questions in advance. For those of you joining us via Zoom, your questions can be submitted with the Q&A function at the bottom of your screen. With that, Sarah, thank you again. The floor is yours.
Thanks so much, Nate, and thanks to FedSoc for inviting me to moderate this panel. It's a treat to be here virtually with all of you today, and I'm delighted to welcome and introduce this A-plus lineup of panelists. Each of our panelists deserves a much longer introduction than our time permits today, but I'll do my best. I'll start with Morgan Ratner, who's a partner at Sullivan and Cromwell. Morgan has argued 9 Supreme Court cases, including as a court-appointed amicus, and she's filed more than 150 Supreme Court briefs. Morgan clerked for then Judge Kavanaugh on the D.C. Circuit and for Chief Justice Roberts. Next, Liz Kiernan is an associate in Gibson Dunn's Dallas office, where she practices in the appellate and constitutional law group and represents clients in state and federal courts. Liz clerked for Judge Smith on the 5th Circuit and for Chief Judge Pryor on the 11th Circuit. Allison Daniel is our next panelist. She practices at the Pacific Legal Foundation, where she works on cases focusing on preserving the separation of powers and reining in the administrative state. Before her time at PLF, Allison worked at the Institute for Justice and for the Ohio Attorney General. Our fourth panelist is Ariel Davidson, who is an associate at Holtzman Vogel. Ariel's practice focuses on commercial litigation, constitutional law, and appeals. Before joining the firm, Ariel clerked for Judge Menashe on the 2nd Circuit. And last, but certainly not least, is Jen Dickey, who is the Vice President and Deputy Chief Counsel at the U.S. Chamber Litigation Center, which is the litigation arm of the U.S. Chamber of Commerce. Before taking on that role, Jen worked in a variety of senior roles in the Department of Justice. Jen clerked for Chief Judge Pryor on the 11th Circuit and for Justice Thomas on the Supreme Court. The main portion of our program will be having the panelists walk us through the cases. We'll go in the order the cases will be argued, with the exception of 2 cases that the panelists aren't covering. I'll give you a brief rundown on those 2 cases after the panelists tell us about the main event cases. While our panelists are telling us about the cases, we invite you to submit questions in the question and answer function, which you'll see at the bottom of your screen. It's different from the chat function, so please do use the Q&A function instead of the chat function. And after we hear from the panelists, we'll give them a chance to answer your audience questions. So with that, we'll start with our first case, which is Riley versus Bondi, and Allison's going to take us through that one.
Thanks, Sarah, and thank you to the Federalist Society for inviting me to discuss Riley v. Bondi. Riley is an immigration case that raises fundamental questions about access to judicial review. And for full disclosure, I co-authored an amicus brief with my Pacific Legal Foundation colleague, Damian Schiff, on one of the questions in this case. The case is about Pierre Riley, a Jamaican citizen who entered the United States in 1995 on a tourist visa and overstayed and has lived in this country ever since. In 2011, Riley was convicted of a conspiracy to distribute marijuana and possession of a firearm in furtherance of that distribution, and he was sentenced to 25 years in prison. In January 2021, however, at the height of the COVID-19 pandemic, the district court granted Riley compassionate release due to his diabetes and deemed his served time sufficient. Thereafter, he was placed in ICE custody and was ordered removed pursuant to INA Section 238B, which governs expedited removal for non-citizens convicted of aggravated felonies. On January 27, 2021, DHS served Riley a notice of intent to issue a removal order, and the next day, DHS issued a document titled Final Administrative Removal Order, or FARO, finding that Riley had been convicted of an aggravated felony because of the gun charge and must be deported to Jamaica. Riley immediately expressed fear of torture if returned to Jamaica, which triggered a reasonable fear screening under the Convention Against Torture, which is an international treaty whose protections have been implemented into U.S. immigration law. Riley testified that a Jamaican drug kingpin with ties to the government had ordered the murder of several of his family members and specifically threatened to kill Riley if he returned. The immigration judge found Riley credible and granted him Convention Against Torture or CAT protection in July of 2021. DHS then appealed to the Board of Immigration Appeals, which reversed the IJ's decision in May of 2022, which is roughly 16 months after the initial FARO, and they ordered Riley removed to Jamaica. Riley then filed his petition for judicial review in the Fourth Circuit 4 days later, or well within the 30 days of the BIA ruling, and nevertheless, the Fourth Circuit dismissed his petition for lack of jurisdiction, holding that the 30-day period ran from the January 2021 FARO and not the May 2022 BIA decision. Riley then sought Supreme Court review, and the Fourth Circuit granted a stay of his deportation. The Supreme Court took up Riley v. Bondi on two questions, each which reflect circuit splits on the immigration appeal issues. The first question is whether the 30-day deadline for filing a petition for review of a removal order is jurisdictional or merely a claims processing rule that can be waived or forfeited. The Fourth Circuit held that the 30-day deadline is jurisdictional, relying on Stone v. INS, a 1995 decision, and dismissed Riley's petition as untimely since it was filed well after the January 21 removal order. The second question is whether a non-citizen can obtain review of the Board of Immigration Appeals decision by filing a petition within 30 days of that decision, even if that's months or years after the initial removal order. Most circuits hold that they can review BIA decisions on withholding claims when petitions are filed within 30 days of the BIA decision, but the Fourth and Second Circuits have held that the 30-day clock starts when the initial removal order is issued, which is before withholding proceedings even begin. Now, the government actually agrees with Riley on both questions and suggests that the court might even want to GVR in light of recent precedent rather than deciding on the merits. The Supreme Court appointed Stephen Hammer, who is a former Roberts clerk, to defend the Fourth Circuit's ruling. And the three former U.S. Attorney Generals filed a brief defending the Fourth Circuit's ruling as well. On the first question, they primarily argued that the Supreme Court's ruling in Stone v. INS explicitly called the 30-day deadline mandatory and jurisdictional. Their brief argues that Stone still binds the court because the court hasn't overruled it, even if its broader framework has evolved. They say that the jurisdictional deadline is clear-cut. You file in 30 days or you lose. And a flexible rule would invite a messy case-by-case tolling fights, clogging the courts, which is what Congress wanted to avoid with the 1996 immigration reforms. On the second question, they argue that precedent says withholding-only rulings like CAT protection don't merge or toll with the underlying removal order's finality. Rather, the 30-day clock starts with the removal order, not with the CAT denial, making Riley's June filing untimely. They say that Congress fast-tracked removal of aggravated felons like Riley and re-entrants, limiting judicial review to curb delays. And they say that allowing late CAT-based petitions undermines this, especially since CAT relief doesn't actually stop removal, it just redirects it. Now, up here, Riley has drawn significant support. In addition to the government, several amici had filed briefs backing his petition. These include the Constitutional Accountability Center and the National Immigration Litigation Alliance, which argue that the 30-day deadline isn't jurisdictional and should allow equitable tolling. And immigration law scholars and the Pacific Legal Foundation emphasize judicial review's role in protecting rights. And the American Immigration Council and other advocacy groups push for fair process in CAT claims. Just briefly on the Pacific Legal Foundation's brief, we focus on the second question regarding when the 30-day clock starts. We approach this from the perspective of administrative law and separation of powers principles, arguing that an order only becomes final when the agency completes its decision-making process. And under the ordinary meaning of final, administrative proceedings must conclude before judicial review becomes available. We emphasize that the Fourth Circuit's interpretation effectively bars judicial review of CAT claims because these proceedings invariably extend beyond 30 days from the initial removal order. And we argued that interpreting finality to occur at the end of agency proceedings aligns with the court's longstanding approach to judicial review of agency action. A particularly powerful aspect of this case is the life or death stakes. If Riley is deported to Jamaica, he has credible evidence that he'll be killed, but the Fourth Circuit's interpretation would deny him any review of the BIA's rejection of his CAT claim. There's also an interesting parallel to other areas of law, which we highlight in our brief, where the court has rejected interpretations that would create these kind of catch-22 situations. For instance, in Sackett v. EPA, the 2012 case, the Supreme Court addressed the Clean Water Act dispute involving the Sacketts who filled part of their Idaho property with dirt to build a home. And the EPA issued a compliance order claiming that the land was protected wetland and threatened fines up to $75,000 per day if they didn't restore it. The catch was that the Sacketts couldn't get judicial review of that order without first complying or letting penalties pile up, which were potentially millions of dollars, since the EPA argued that it wasn't final agency action under the APA. The court disagreed, holding that the order was final and reviewable. This case and other cases that we cite in our brief underscore the court's aversion to procedural setups that delay or deny judicial oversight, a thread that echoes in Riley's fight over the timing of immigration appeals. Just as in Sackett, where the court rejected schemes requiring parties to risk severe penalties to obtain judicial review, here the Fourth Circuit's interpretation would require non-citizens to file for review before they even know if they need it. So what is the court going to do here? Granted, I'm not an immigration law expert, but we think that the court is likely to rule for Riley on both of these questions. The most natural reading of the statute is that an order for removal isn't final until the agency has completed all the proceedings, including those on the CAT claim. And the court's recent decisions in Santos-Zachariah v. Garland and Harrow v. DOD strongly suggest that the 30-day deadline is not jurisdictional. The court has repeatedly emphasized that filing deadlines are rarely jurisdictional absent clear congressional intent. However, the court might prefer a narrow ruling focusing just on the finality question, which would resolve Riley's case while leaving the jurisdictional question for another day. That is, the court could skip whether the deadline is jurisdictional by just deciding when it starts. If it's the removal order, Riley is out. If it's the CAT ruling, he's in. Either way, they don't have to touch the jurisdictional fight. I'll close by noting that Riley v. Bondi tests a pattern. The court often ensures meaningful judicial review in immigration cases despite statutory limits. It's a chance to affirm that Congress didn't intend and perhaps can't constitutionally allow agency decisions on fundamental rights to escape court scrutiny entirely. Thanks.
Thanks so much, Allison. So that's the case. That case will be argued on next Monday, March 24th. And for our Tuesday cases, Jen Dickey will tell us about both of those cases involving the EPA.
Thank you. Thank you to the Federalist Society for having me. Of course, any opinions I express or errors I make are my own. Starting with EPA versus Callais, this is a case about venue for judicial challenges under the Clean Air Act's Renewable Fuel Standard program, which basically requires that increasing amounts of renewable fuels be blended into the gas and diesel that's sold in the United States. EPA sets the annual percentage standards across the industry, and then refiners and importers use these standards to figure out how much renewable fuel they have to blend themselves or purchase from others that blend. Because Congress recognized that this program could impose special burdens on small refineries, which lack the inherent scale advantages of larger refineries and may be limited in their ability to blend, Congress allowed them to individually petition EPA for an economic hardship exemption from the annual obligations. The issue here is about venue for challenges when the EPA denies such an exemption. So generally, under the Clean Air Act, there's like a three-prong judicial review provision. First, a petition for review for certain specified actions like setting a national primary ambient air quality standard, quote, or any other nationally applicable regulations, end quote, may be filed only in the DC Circuit. Then there's a list of specified actions like promulgation of state implementation plans and any other final agency actions which are, quote, locally or regionally applicable, end quote, may be filed in the appropriate circuit, which is usually like a regional circuit where the petitioner is based. Except that a petition that is locally or regionally applicable may be filed only in the DC Circuit if the action is, quote, based on a determination of nationwide scope or effect, and if in taking such action, the administrator finds and publishes that such action is based on such a determination, end quote. So national actions, DC Circuit, state and local actions, regional circuits, except if there's a national sort of nationwide scope or determination underlying it. So when EPA denied small refinery exemptions in the past, the refineries brought petitions for review in their regional circuits. EPA had a string of losses. Then under the Biden administration, EPA simultaneously denied 36 previously decided hardship petitions. It actually reversed itself on 31 of those where they had previously granted it. And so it did it in like one action and then attached confidential refinery specific appendices for each refinery to that document. The overarching reasoning was that the refinery should be able to pass on 100% of the compliance costs for the program in the price of the fuel they resell, so there's no economic hardship. EPA then used largely the same reasoning to deny another 69 hardship petitions in the same format, simultaneously with separate appendices. So some small refineries filed petitions for review in the Fifth Circuit, and EPA moved to transfer those to the DC Circuit, asserting that the decisions were either nationally applicable or else based on a determination of nationwide scope or effect. The Fifth Circuit denied those motions, concluding that EPA had conceded that it had considered each petition on the merits, and the separate appendices confirmed that its final actions relied on refinery-specific determinations about each refinery's own economic hardship factors. So these are locally or regionally applicable actions. They're not nationally applicable. And then it ruled that the denials on the merits were impermissibly retroactive, contrary to law, and counter to record evidence. Other small refineries filed in the DC Circuit or in other regional circuits and had their petitions transferred to the DC Circuit. The DC Circuit ended up unanimously agreeing with the Fifth Circuit on the merits that the denials were contrary to law, but had a little bit different reasoning. So the SG petitioned for cert on the venue question. And the acting SG under the new administration has adhered to that position, although she has reported that the EPA is reassessing the basis for the underlying denials. But in the meantime, they are basically arguing both that the denial actions were nationally applicable because they resolved the exemption petitions of small refineries located in multiple judicial circuits, and they're also based on a determination of nationwide scope or effect because they were based on EPA's statutory interpretation and economic analysis of marketplace conditions. So I never try to predict the Supreme Court. I will say the biggest weakness in the SG's position, I think, for this court is that it seems to give the EPA a lot of room to manipulate where a judicial review can occur. And Congress clearly wanted local or regionally applicable actions to be primarily reviewed in the regional circuits, closer to where the petitioners are based, and thus presumably reducing the costs of challenging agency action. But the biggest weakness in the small refinery respondent's position is that it seems to make the nationwide scope or effect prong of the venue test pretty insignificant. And it also raises the specter of conflicting decisions evaluating the same EPA reasoning, which Congress clearly was trying to avoid by aggregating most challenges to policies with broader national scope in the DC Circuit. So there's actually a group of refineries supporting the SG in this case because they are concerned about that conflicting framework and the sort of uncertainty it injects into the supply chain. I'm hoping that regardless of what the Supreme Court decides, it will give us some clear guidance on how to read this interlocking judicial review provision because it's causing a lot of litigation. And in fact, that litigation leads us to the second case for Tuesday, which is Oklahoma versus EPA. It's very similar in that it also involves the same judicial review provision. What differs is the program at issue. So under the Clean Air Act, EPA is responsible for establishing national ambient air quality standards for certain pollutants. The states then establish state implementation plans to implement those national standards. Each state submits its plan under Section 7410, which EPA shall approve if it meets all the applicable requirements. It's important to note at the outset that in the list of local or regionally applicable actions that would normally go to the regional circuits, the judicial review provision includes any EPA action, quote, approving or promulgating any implementation plan under Section 7410. So approvals of state implementation plans normally go to the regional circuits. It also has language that says any other final action of the administrator under this chapter, including any denial or disapproval by the administrator under subchapter 1, which is local or regionally applicable. So denials of state implementation plans also usually presumptively in that regional circuit bucket. But then in 2015, EPA revised the national ambient air quality standards for ozone. The state started to develop implementation plans. They submitted them, including their compliance provisions for the good neighbor provision, where they have to make sure that their emissions aren't harming the states next door and meeting their Clean Air Act obligations. So EPA approved 24 state plans, and those approvals, it said, are state or locally or regionally applicable actions reviewable in the regional circuits. But EPA then proposed to disapprove 23 state plans. And after taking comments, it finalized the disapproval of 21 of those plans. It did so in a single Federal Register notice. And although the notice included individual discussions of each state plan, EPA asserted that its state plan disapprovals were nationally applicable because the notice covered a large number of states across the country and because of the interdependent nature of interstate pollution transport and the common core of knowledge and analysis involved in evaluating the submitted state plans. EPA also asserted that the rulemaking in the alternative was based on a nationwide scope or effect, a determination of nationwide scope or effect, because it was relying on a common core of nationwide policy judgments and technical analysis. So some of the states challenged these disapprovals in the regional circuits. The 4th, 5th, 6th, and 8th circuits all declined transfer motions to the DC circuit, saying these are locally or regionally applicable actions. The 10th circuit alone disagreed and transferred. The 10th pointed out that the notice in question disapproved 21 state plans from across the country. EPA had applied a uniform statutory interpretation and common analytical method, so it concluded that this was in that first bucket of nationally applicable agency actions. It did not rule on the sort of exception piece for locally or regionally applicable actions that are based on a determination of nationwide scope or effect. So the previous administration's SG filed for was defending these actions, and the respondent posture full-throatedly defended them, said on the nationally applicable point, the SG or the EPA's position is correct because the text clearly indicates that there is supposed to be one appropriate circuit for locally or regionally applicable actions, that like you would have one place where this is based for judicial review, the place where the refinery is located, for example. And an EPA action that implicates entities across circuits is not going to have one appropriate circuit. There's going to be a bunch of them. And so that must mean that this is a nationally applicable action that goes back to the DC circuit. The SG also continued to press the alternative argument, noting that an agency final action may rely upon multiple determinations of nationwide scope or effect, and arguing that Congress entrusted EPA with the discretion to determine the proper venue as the agency saw fit. Notably, following the change in the administration, the acting SG tried to get this case held in abeyance, noting that the EPA's acting administrator wanted to reassess the underlying disapprovals. But the petitioners, Utah and Oklahoma, opposed, noting that concerns about this venue provision have been raised repeatedly in all sorts of cases, and it was producing wasteful and time-consuming litigation, and the court should provide guidance now. The court ultimately declined the acting SG's motion and is going to proceed to consider this. So I think this case, combined with Calumet, gives them more room to explain how these three interlocking provisions work together, what discretion EPA has in putting something in the nationally applicable bucket or the exception bucket for nationwide determinations versus sort of the things specified in the statute that are presumptively locally or regionally applicable. I think it should be an interesting pair. I think you kind of have to listen to the arguments together, because I expect we'll see a bunch of the same concerns animating the questions in Calumet that are applicable to the Oklahoma action as well.
Great. Thanks so much, Jen. To round out our first week of argument, on Wednesday, March 26th, the court will hear FCC v. Consumers Research in the consolidated case. Morgan, you want to tell us about those?
I do. Thanks, Sarah. Thanks to the Federalist Society. So this case is a potential biggie. This is about the non-delegation doctrine. I will start by giving the standard disclaimers. I submitted a brief on behalf of the U.S. Chamber of Commerce, and of course, I'm not giving its views here. Let me start with a little background on what non-delegation is. Many of you probably remember this discussed in your law school classes, but the idea is really simple enough, right? Article 1 vests legislative power in Congress. Article 2 vests executive power in the president. And the hard question is, when does an executive agency stop executing and start legislating? And the non-delegation doctrine is designed to police that line. The problem is, it's a hard line to police. And so courts for the last century or so have pretty much thrown up their hands and not tried all that hard to do so. Cass Sunstein famously said that the non-delegation doctrine has had one good year and 200 bad ones. So this case, the question is, is it going to have another good year, year round two? To get into the particulars of this case, it involves the Universal Service Fund, which is administered by the Federal Communications Commission. That's basically a telecommunications social welfare program. You see a charge on your bill that is used to subsidize certain programs, primarily in remote and low-income communities, to ensure telecommunications capabilities there. So you can check your bills at home. You'll probably see something labeled Universal Service Fund fee. That's what it is. It's this program. There are two things that you really need to know about the USF. The first is that Congress said a lot of things about it, entities that should contribute to it, the sort of entities that should receive funds, the goals of the program. But what it wasn't super prescriptive about is exactly how much the fee should be, how big this charge should be, how much you should be paying on your bills. And that's going to be really important to the non-delegation issue. The second thing you need to know is that it's administered in part by a private nonprofit. It's disputed exactly what role this private nonprofit has, but we can, I think, agree that it more or less comes up with the financial projections to compute the charge that appears on your bill, right? So it tends to come up with the numbers, and the FCC could change them, but it historically hasn't. So a number of groups sued, arguing that the USF is an unconstitutional delegation from Congress to an executive agency, and a further unconstitutional delegation from that executive agency, the FCC, to a private group. Sort of two levels, a public non-delegation problem and a private non-delegation problem. And the Fifth Circuit, I should say the challengers lost that argument in the 6th and 11th circuits. They won it before an en banc Fifth Circuit. And the Fifth Circuit's decision is really interesting. It says sort of, we're skeptical whether this is a acceptable delegation from Congress to the FCC. Again, the public non-delegation doctrine, but we don't have to say that that's a problem. We're also skeptical about whether this is an appropriate delegation from the FCC to the private administrator. Again, the private non-delegation doctrine. But we also don't have to say that's a problem. But what we are going to say is that at a minimum, these two things in combination are a problem. So that's the case that goes up to the court. And as presented, we could see it going a bunch of different ways, as I think should be obvious from that description of the decision below, right? I will flag briefly, the Supreme Court added a question here about mootness, whether the case is moot because the challengers didn't seek preliminary relief and the contribution expires every quarter. Nobody took the bait on that in the briefing. It's kind of weedsy, so that's about all I'll say on this, except to note that if you're listening to the argument, there is a sort of total off-ramp that the Supreme Court itself inserted into the case as a potential way to resolve it. Then there's the private non-delegation aspect. That would be the significantly smaller holding from the court. Everybody agrees that federal agencies can, I should say, solicit non-binding recommendations from private entities. And everybody agrees that federal agencies can't just hand over their power in a binding fashion to a private group. And the question is really sort of case specific. Like what happened here, the FCC has a formal ability to control, but it practically doesn't exercise it a whole lot. Is that enough to say that this really is an impermissible delegation? Whatever the court says on that, it's probably not going to have the most sweeping effects beyond the Universal Service Fund. There's another case involving the body that regulates horse racing, which is also includes a significant private group as part of that. But this is not going to be sort of regime change if the court takes a private non-delegation route here. There's also the sort of middle holding, similar to what the Fifth Circuit did, which is, can you add up a partial constitutional concern here with a partial constitutional concern there, and you put them together, and that equals one whole constitutional violation. On first hearing that, it may sound a little funny, but we do that in other areas of the law. I think the analogy that the challengers rely on here is removal restrictions, right? We may think one level of removal restriction is okay, 2 levels is not. And you could think of this analogously as sort of 2 levels of removal from the legislature. So that's a sort of mixed holding that is possible and would probably be significant because it would require the court to say something on the public non-delegation side. But that's the biggie, so I'll get to that one now. The big holding is saying something new on the public non-delegation doctrine. So for the last century or so, the rule has been that delegation of authority to agencies is fine if it contains an intelligible principle. The meaning and propriety of that standard have certainly long been contested, but there have not been many things that have failed that test. And so the search here is that the right test? Is there a better test? And what can really satisfy 2 things? What can be both administrable and consistent with text and original understanding? And those 2 things are probably going to be the guideposts for the court as it searches whether to adopt a new test. There are a lot of amicus briefs in this case, and in addition to the party briefs, I think there are about, I'd probably say 5 potential tests that might come out of this if the court reaches the public non-delegation question. The first is to leave things exactly as they are, right? This is the government's position, more or less, that Congress has to delegate power to the agency and give the bounds of that power, and beyond that, a policy that the agency must pursue is good enough. Option 2, keep the intelligible principle as a guiding, the guiding test. We'll keep the name the same, but ratchet up what it means. Require an actual rule of decision making, not just a goal. So guidance more than an objective. Option 3, and this I think is mostly the option I'd say the challengers are pushing here. Change the sort of toggle the non-delegation requirements based on the nature of the right or the power at issue. So for something like the taxing power, require more from Congress, because that's really a power we think of as kind of in the legislative wheelhouse. So it's maybe it's not a trans-substantive rule, it's sort of right specific. Option number 4, if I'm counting right, is the scope of the delegation or the size of the delegation should control how much guidance we need from Congress. This is the position that I think is laid out best in the Chamber's brief, effectively a proportionality test. When you've got the most basic administrative or implementation authority, you don't need much guidance at all. As you increase into policy making, then you do need more from Congress, both the sort of object and the means of how to get there. And at the highest level, things that are truly, truly major, Congress perhaps can't delegate those at all. And then option number 5, and there are variants in this among the briefs, sort of no delegation of any legislative power at all. So agencies may be able to adjudicate public rights. There may be laws that allow them to, or sort of enable their existing authority, maybe some filling up of details. It sort of depends on the amicus you're looking at, but a pretty restrictive view on no general policy making out of executive agencies. So I think those are the 5 buckets that most of the tests fall in. And you've got 5 buckets within one of sort of the ways of resolving the case. You've got 3 other ways of resolving the case. So there are a whole lot of off-ramps for the court. I expect that we'll see real splintering at oral argument, because different things, practicalities, text, original practice, are going to be appealing to different justices. So it's hard to predict in advance which one of these routes they're going to take, but it'll be a very interesting argument. And I expect some light fireworks in this one. Back to you, Sarah.
Thanks, Morgan. Definitely one to watch. So that wraps up our first week of argument. I'll remind all of our watchers and listeners to please submit your questions through the question and answer function that you can see at the bottom of your screen so that we can get those to our panelists. Turning to the second week of oral argument, on Monday, March 31st, the court will hear Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission, which Liz Kiernan is going to tell us about.
Thank you, Sarah, and thank you to the Federalist Society for having me today. All views are my own, any errors are my own, and as a disclaimer, I did in fact file 2 amicus briefs on this case at the court. So very excited to be here to discuss it today. So the question presented here is, does the state violate the First Amendment's religion clauses by denying a religious organization an otherwise available tax exemption because the organization does not meet the state's criteria for religious behavior? It's great that this case is up at the court right now, because if you are a religious liberty fan, you might have noticed that we've had a little bit of a desert in the last year and a half. The last time a religious liberty case was argued at the court was in April of 2023. So it's a little unusual not to have any religious cases in an entire term these days. And so now Catholic Charities Bureau is kicking us off with a trio. In January, the court granted 2 other ones that'll be argued next month. But this case involves exemption from a state unemployment tax system. So similar to the federal government, which will come into play later, Wisconsin exempts from its state unemployment tax system certain religious organizations that are, quote, operated, supervised, controlled, or principally supported by a church or convention or association of churches, and that are also, quote, operated primarily for religious purposes. So the petitioner here, Catholic Charities Bureau, is the main charitable arm of the Catholic Church. But the way the Catholic Church organizes itself here, at least in America, is that the Catholic Charities Bureau is separately incorporated from the Catholic Church itself. So it has its own 501c3 status. And that separate incorporation is actually motivated out of a religious belief by the Catholic Church in what they call the subsidiarity doctrine, which to boil down, at least from my view, it seems to be similar to the U.S. Constitution in terms of federal and state, and having what can be done on a local level should be done on a local level at the smallest unit possible. So that is their motivation and belief in having these separate organizations. But importantly, the Catholic Charities Bureau is the church's charitable arm. So it is still supervised, controlled by the church, by the diocese that it's operating in. And it is obviously religiously motivated. It's flowing out of the church's belief in charity. So recently, the church is obviously, Wisconsin has no problem with exempting the church from the unemployment tax system, and the church uses its own. In Wisconsin, it has its own unemployment tax system for its constituents. And the Catholic Charities Bureau and the organizations underneath it would also like to have this exemption so it can too participate in the church's own version of the unemployment program. So they applied to have their status adjusted so that they could be exempted. The Wisconsin denied that. They went through a series of appeals all the way up to the Wisconsin Supreme Court. And the Wisconsin Supreme Court also denied the Catholic Charities Bureau and the suborganizations under it the exemption. Under the Wisconsin Supreme Court's view, I think it made basically two key moves. First, when analyzing whose purposes, what organization's purposes for purposes of the religious purposes analysis, it cabined off the church's purposes. It said, because you've chosen to separately structure yourself, we will not consider the church or the diocese as part of our religious motivation analysis. So it focused purely on the Catholic Charities point. And that reasoning, the charities say, basically cuts to the core of how the church has chosen to organize itself, the church autonomy doctrine. It's conflicting with the church's ability to order its affairs. It burdens its practice of subsidiarity, which says you should be categorizing these at the lowest levels. And it also discriminates on the church against the church based on how it's chosen to structure its religious organization. So that's one bucket. And then the second kind of key move here is that the court accepts that even the charities are operating for a religious purpose, but says that's not the only thing we have to look at. We also, the statute uses the phrase operated primarily for religious purposes. And it reads into the word operated a requirement to look at the activities the organization is engaging in specifically, and whether or not those are, in its words, typical activities of a religious organization, or in the words of the dissent, a stereotypical view of a religious organization. And so those would be things that, like, of course, worship or proselytization or communion. And a lot of what the Catholic Charities Bureau is doing, and particularly the four organizations underneath it that are at issue here, they're catering to the developmentally disabled. So the Wisconsin Supreme Court reviewing this decided that those are more social activities. They are not inherently religious. And so it held that they was not for a religious purpose at the end of the day and did not qualify for exemption. Importantly, in reaching that decision, it suggested a few things. It said that if they were catering, for example, to the developmentally disabled and also proselytizing at the same time, that might be okay. But the problem with that, as our amicus explains, and also the petitioner explains, is that in the Catholic faith, charity is supposed to be in and of itself. It is not supposed to be for purposes of proselytization, and that actually it violates Catholic faith to proselytize while you're trying to be charitable to others. So things like that, they're basically placing burdens on religion to change how they would their beliefs. And basically, as I said, they would require stereotypical or typical activities to qualify. Of course, they say that's not what they're doing, but then, as I said, they gave the example of the proselytization. That could have changed this facts, they said. They also gave an example of an orphanage that is run, let's say there's an orphanage run by nuns. If the orphanage was separately incorporated from the church, that is a charity, even though it's being run by nuns, for religious charitable purposes, that wouldn't even qualify because of the separate organizational status. So these two key moves that the court does really kind of blend together to set up what is at the court now. And there's multiple state Supreme Court splits on this. Several courts have said, no, it's just you look at, Supreme Courts have said, no, you just look at the religious purpose. Several courts have said, no, we can kind of go into the activity. So we now arrive at the Supreme Court with this set up. This is in the petitioner's words, basically the intersection of both the current Establishment Clause jurisprudence and Free Exercise Clause jurisprudence. The petitioners argue that it's unnecessarily entangling the state in determining what is or isn't religious under this, and violates the Establishment Clause that way. Also obviously violates the church autonomy doctrine, but then it's also burdening the religion, their religious practices, because it's discriminating against the church in terms of how their beliefs and how they are set up, and burdening the church in that way. So it's also the free exercise aspect of it. The state of Wisconsin says that it would be more entangling for them if they had to constantly look at whether or not the organization was being what if a organization that has a social activity to it primarily was always having the religious purpose. This way they have one kind of neutral rule to decide whether or not an activity is religious, and they just have to make the decision one time, and they're not constantly having to go back and make that decision. The government, the United States filed an amicus brief here as well. As I mentioned earlier, there is a federal parallel statute that is almost identical to Wisconsin's. The government has an interest in it being interpreted correctly. They make an interesting request that since this is a Wisconsin statute, typically the statutory interpretation question of whether operate requires the look at the activity would not be before the court right now. But the federal government has suggested the court still look at that statutory interpretation question because it's subsumed it's logically subsumed by the question presented. If operate was misinterpreted, you wouldn't even have to probably wouldn't have to reach a lot of these constitutional questions. And also because it is the parallel federal statute, they're worried that it's might mess up federal law as well. I'm not sure if the justices will fight on that because it will, again, as I said, kind of involve questioning the state court about the interpretation of a Wisconsin state statute, but it'll be interesting to see how that comes into play. As I mentioned, the petitioner Catholic Charities Bureau is actually raising an Establishment Clause violation here, which is, I think, a little more unique in the religious case context. Usually you see that being more forcibly argued by the state or the federal government. And the state is arguing a little bit that it would violate the Establishment Clause the other way, but the Establishment Clause argument is primarily being pushed by Catholic Charities Bureau. So it'll be also interesting to see we know there are some justices like Justice Thomas on the court who does not view who views the Establishment Clause differently from the entanglement test. So it'll be interesting to see, I think, how the justices, if they decide to call this a free exercise problem, Establishment Clause problem, or both. And that should be a good question to answer. I expect we'll see some separate writings on it at the very least.
Great, thanks, Liz. Next for Tuesday, April 1st, the court will hear FOLD v. Palestine Liberation Organization and the consolidated case. So Ariel will tell us about those cases.
Well, thank you so much to the Federalist Society for having me. Thank you to Sarah for moderating. As a disclaimer, all the opinions are my own, all the errors are my own. We actually, myself and my firm, we submitted an amicus brief in this case on behalf of a group of Jewish and Zionist organizations in support of the terror victims who brought suit against the PLO and the PA. So this case is very factually rich and also legally rich. So I'm going to do my best to not give a winded presentation on this. And if there are deeper questions that I can answer, I'm happy to do so during the Q&A. The core issue that this case gets at is whether the Promoting Security and Justice for Victims of Terrorism Act, it's the PSJVTA, which is quite a long acronym, so I'm going to call it the act at issue to spare everyone's ears, whether the act at issue violates the due process clause of the Fifth Amendment. And baked into that core issue are two subsidiary questions. The first one being, what are the limits of consent jurisdiction for the purposes of personal jurisdiction? And then to what extent are the due process requirements of the 14th Amendment in the context of personal jurisdiction applicable to the Fifth Amendment? To give you a bit of background about this case, the petitioners plaintiffs are a group of nearly a dozen either families of victims of terrorism or the victims themselves. They were injured and survived the attack. And in particular, they are victims of Palestinian terrorism. The named plaintiff, Fuld, in particular, was a dual American-Israeli citizen. He was born in New York and immigrated to Israel in 1994. He was stabbed to death in 2018 outside a supermarket in Efrat, which is a town in Judea and Samaria. He was 45 years old. He was a father of 4 children. And he actually, was just a normal civilian standing outside, stabbed by a Palestinian terrorist, then chased the terrorist to prevent him from stabbing others, and he eventually succumbed to his wounds. As a result, the basis of this claim is that these various victims of Palestinian terrorism have brought a claim under 18 U.S.C. Section 2333, which is the Anti-Terrorism Act, which allows for those who are U.S. nationals or U.S. citizens or the family members of U.S. citizens to bring a claim of material support for terrorism. And in particular, this is based off of the Palestinian Authority and the PLO's pay-for-slay system, which, if you are familiar or not familiar with it, it's a pretty gruesome, what they would call welfare program, where effectively, if you engage in an act of terrorism against Israeli Jews, you will be compensated by the Palestinian government. And that compensation can take a variety of forms. You can be compensated in terms of a payment, monthly stipend. You will be given job prospects after you are released from Israeli jail, if you do Israeli prison, if you do survive the attack. And then if you are, quote, martyred, your family will be compensated ad infinitum. So this system is obviously quite gruesome, but what makes it even, I would say, even more horrifying is that your stipend is based off of how many years you spend in Israeli prison. So effectively, the more victims that suffer as a consequence of your martyrdom, the greater the payment that you or your family may receive. And so it's clearly an incentivized system that allows for increased acts of terrorism. And many times, in many cases, I should say, the victims of such terror attacks end up being American citizens. So when this case was brought, it was Southern District of New York, opinion came down, declining to exercise jurisdiction in June 2022. The Second Circuit affirmed in September of 2023. There was a denial to rehear en banc in May 2024, and then cert was just recently granted in December 2024. So what I'm going to do is talk a little bit about the history of the act at issue, so the PSJVTA, and a little bit of the volleying that's taken place between Congress and the courts when it comes to exercising jurisdiction over foreign entities, but in particular over the PLO and the PA. And then I will talk a little bit about, in particular, Judge Menashe's dissent in the denial to rehear en banc, because I think it substantively presents the best, most cohesive argument that I think the Supreme Court will be very convinced by, long story short. So I will go into a little bit of history to start off. The PSJVTA was enacted in 2019 for this precise purpose that this case exists, namely to prevent dismissals based on lack of personal jurisdiction in civil actions against the PLO and the PA when those actions are brought under the ATA or 18 U.S.C. to Section 2333. Which provides a damages remedies for United States nationals who are either killed or injured by an act of international terrorism. This is the act at issue was part of a legislative effort to create a basis of personal jurisdiction over non-resident defendants, but primarily based on alleged consent. And that would provide an independent constitutional basis for subjecting a non-resident defendant to litigation in federal courts in the United States. And so what are these two bases of jurisdiction? They're actually pretty straightforward under the act at issue. If you make payments directly or indirectly to a terrorist that injures or kills a U.S. national, or you make payments directly or indirectly to the terrorist family members, which, as I mentioned before, is another option that another path that the PA has taken, that would make you liable to be brought into federal court in the United States. And then also, if you undertake any activities in the United States, it's a pretty broad scope, but there are exemptions for UN duties and meeting with U.S. officials and representatives. So there is a carve out for sort of diplomatic activities, but anything beyond that, you are subjecting yourself to possibly being brought into federal court in the United States. And so where did this act come from? So what prompted Congress to pass the PSJVTA? Because as you can tell, pay for slay is a very unique program. It's unique to the PA and the PLO. So for Congress to pass an act saying that that's a basis, effectively that arrangement is a basis of jurisdiction, seems very on the nose. And so the question would be like, how did we get to this point? Well, the Second Circuit was again at the center of it. They decided a landmark case referred to as Waldman, where the Second Circuit refused to exercise jurisdiction. They actually reversed a substantial jury verdict where there were a number of families who had brought suit again against the PLO and the PA. Jury decided in their favor, and then the Second Circuit reversed. And the position of the Second Circuit in Waldman was that there was neither general personal jurisdiction nor specific personal jurisdiction. So they said, look, the PLO and the PA are not at home in the United States, so general personal jurisdiction off the table. They said that with regards to whether the PLO and the PA were targeting the forum at issue, the United States, they said that it was relatively incidental that the victims were U.S. citizens. And Congress was completely taken aback by this. And, terrorism financing has really been, if you follow it all sort of the foreign affairs interests of Congress, terrorism financing is a huge component of what Congress has been actively trying to go after, I think, in the post 9/11 world. 9/11 was definitively a inflection point in how the United States, and in particular, our Congress looks at how to deal with terrorism financing. And so if there is any opportunity that Congress sees to deter the killing of U.S. citizens abroad by terrorists, they will take that opportunity, i.e. Congress. And so they saw the decision in Waldman, and they responded in 2018 with the Anti-Terrorism Clarification Act, which added a provision to the Anti-Terrorism Act allowing for a party to deem to have consented to jurisdiction if after 120 days of the passage of that act, the defendant accepted certain forms of aid from the United States or maintained an office in the United States. And so immediately, it was very clear that this act, the ATCA, was targeting the PLO and the PA for jurisdictional purposes. Because the types of aid at issue were very specific to what the PLO and the PA accepts from the United States. This is another component or another added layer, is that we give a lot of aid to the PA and the PLO, and then to have them shuttle, money is fungible. To have that aid then be used to finance the death of U.S. citizens abroad is really discomforting, discomforting for Congress, and it should be. So as a result of the passage of the ATCA in 2018, the PLO and the PA denied assistance. They shuttered from those particular funds. They shuttered their offices. And then again, Congress responded with the PSJVTA, which is the act at issue. And again, the Second Circuit declined to exercise jurisdiction when the question presented itself in Waldman 2. So this brings us now to Fuld, which I should note that Fuld and Waldman are bringing their case together before the Supreme Court now. And so the Waldman case, despite being the Second Circuit declining to exercise jurisdiction twice, is still alive. So I'm going to talk a little bit now about how Fuld plays into this, and then go into a little bit of the due process considerations, and then I will cede the floor back to Sarah. So when it comes to, in particular, Fuld, as I said earlier, SDNY said that it could not exercise jurisdiction, and then the Second Circuit also affirmed. What's interesting about Fuld versus Waldman is that Fuld, the plaintiffs here were not arguing for general personal jurisdiction. They were not arguing for specific personal jurisdiction. They were actually arguing on a theory of consent, because the statute's predicate conduct amounts to implied or constructive consent. So if we remember the basis of jurisdiction, the first one being paying terrorists or their family members, the second one being any activities conducted in the United States. And so any activities that are sort of extraneous to your diplomatic activities. So if you're, if you live in the if you're conducting social media activity in the United States, if you're operating an office in the United States, if you're updating your website using servers in the United States, all of those could be activities that may make you, that may make it possible to drag you into U.S. federal courts. And so that is considered a form of implied consent, according to the plaintiffs. And unfortunately, the Second Circuit was not convinced by that argument. And I think they had a very sort of very strict and narrow reading of what consent looks like in the context of personal jurisdiction. And so they listed, contract, if you have like a forum selection clause. They talked about appearing before a court in litigation. And then also they had a very, I would say, narrow reading of the acceptance of a government benefit. And I'm going to unpack a little bit what that is and what the case law says about that. But effectively, they denied that there was any sort of consent at play here. And so for that purpose, they declined to exercise jurisdiction. I think Judge Menashe's dissent from the denial of hearing en banc is the most helpful in kind of giving us a window into the arguments that are being made by the petitioners in their briefs, as well as what I think the Supreme Court will find most compelling. As a preliminary matter, when we think about due process, sovereign states are not subject to the due process requirements. And so in this particular instance, what's interesting is if Palestine were actually a sovereign state, as the PLO and the PA allege, then the PSJVTA act at issue would be perfectly constitutional, because there wouldn't be due process considerations. I think the other element that's important here is, due process is about preventing litigation in an inconvenient forum. We don't want to be dragging defendants into places that they really can't get to. But defendants here, PLO and the PA, they lawfully maintain offices in the United States. In this particular case, the chief representative of the PLO and the PA was actually served in his house in the United States. And they also, via the statutory predicates, were given clear notice of what their continued contact amounted to consent. And so I think that one mistake that the Second Circuit made in its opinion that Judge Menashe highlighted quite well was that, it's not a foreign entity doesn't necessarily consent to jurisdiction under the 14th Amendment only if there is a reciprocal benefit conferred by the United States. So this was the big argument made by the Second Circuit, was that there wasn't this magic formula or specific agreement in place that said, hey, we're accepting jurisdiction. We're doing this explicitly. And they relied on this case, Mallory versus Norfolk Southern Railway Company, which, quote, held that Pennsylvania may deem via statute an out-of-state corporation's registration to do business to be consent to personal jurisdiction in Pennsylvania. And in this particular instance, in Mallory, there was a statute on the books in Pennsylvania that effectively said, if you have registered as a business in Pennsylvania, you have consented to jurisdiction. And so that was considered to be deemed consent. Once you registered, you had consented. In Mallory, this case in particular, there was no separate agreement that said, hey, you now consent to personal jurisdiction. Rather, as is the case here, there's a separate statute, the PSJVTA, that declares that a specific activity is sufficient to establish personal jurisdiction. And so in a way, it's odd to me because it's not clear to me why the Second Circuit has sort of created this level of explicitness that's just not readily apparent in Mallory, which is the big case that deals with the idea of deemed consent. And so at the end of the day, the focus should be on the knowing and voluntary nature of the defendant's conduct, not necessarily whether this was an explicit arrangement or a quid pro quo between the forum and the foreign defendant. And so I actually think ultimately, too, when going back to the notions of fundamental fairness, there's nothing, unfair about making an organization that pays terrorists to kill American victims. Nothing unfair about dragging them into U.S. courts, I personally think. And then the other side of it is that, if you are conducting any sorts of activities in the United States, that's very similar to conducting business. And that was the basis of deemed consent in Mallory. So I think that the Second Circuit really read an explicitness requirement to Mallory that's just not obviously present. And then I think even if you said there were such a requirement, it has been satisfied because the defendants are residing and doing business in the United States. And so the petitioners gave various examples of activities that the PLO and the PA are engaging in, never mind just maintaining offices here, engaging in social media activity, conducting press conferences, distributing materials. What's interesting about this is that if, there were, it brings into play all sorts of questions about, what actually constitutes the activity enough to be on the radar of the courts. And in this particular instance, I think the PLO and the PA more than satisfy that. The other thing that was interesting that the panel in the Second Circuit made in the argument that they made in their decision was that, because the PLO and the PA are engaging in certain activities in the United States in contravention of U.S. law, we actually don't bless or endorse the PLO or the PA on U.S. soil because they're doing so in contravention of U.S. law. They're not actually getting a reciprocal benefit. But that's an absurd argument to make. Firstly, the U.S. government has engaged in a practice of non-enforcement. So you could say in some ways that it's implicitly blessed or impliedly blessed. And then secondly, it's a weird, absurd result, right? So if a defendant engages in non-blessed or illegal conduct, and they're still extracting a benefit from the forum, they're more protected from being brought into court than a foreign entity who would be engaging in legal conduct. So the idea that you get more protection for engaging in illegal or non-blessed conduct is absurd. And then I think there's also an element, the last argument that's being made here, which I think hits to the crux of what the Supreme Court will be reviewing, is whether the 14th Amendment actually imposes the same requirements for due process in the personal jurisdiction context as the Fifth Amendment does. And this is where I think the Supreme Court is going to find the most interesting legal question. This is an open question of law. It has not been addressed. The restrictions of the 14th Amendment when it comes to due process were born out of federalism concerns, i.e., we don't want states stepping on the toes of other states when it comes to litigating their affairs. And personal jurisdiction in the state context is obviously quite different than in the federal context. The Fifth Amendment, in the position of Judge Menashe, and I think he is correct in this, and maybe I'm biased as a former clerk, but the Fifth Amendment does not limit the personal jurisdiction of the federal courts. Rather, all it requires in its text is that deprivations of life, liberty, or property have to be preceded by a process of law in a very narrow and technical legal sense. And so, there have been instances in which Congress has historically overridden various limitations on federal jurisdiction, even if another sovereign might find it repugnant. Actually, Justice Story has a longer soliloquy on that in Piquet v. Swan, where he talks specifically about how, there are instances where Congress will make decisions that foreign states might find repulsive, but that doesn't necessarily mean that they're de facto unconstitutional. And then ultimately, the executive branch has an interest in conducting its own foreign affairs, and that may come up against questions of questions related to due process under the Fifth Amendment. That is a very unique consideration that, again, is unique to the federal government and not to state governments. And so when we talk about whether the requirements of the 14th Amendment should be transposed onto the Fifth Amendment, I think, in my opinion, I think it's rather clear that that's not appropriate. And then I'll talk a little bit about, I guess, the larger implications of this case, because I think it's quite important. Again, it is an open question of law, the relationship, the tension between the 14th Amendment and the Fifth Amendment. But it also introduces questions of consent of foreign defendants more generally. We will have probably a lot of anti-terrorism cases coming down the pipeline post October 7. So I think that litigation against the PLO and the PA is going to become even more poignant. And so I think that, Congress and the executive branch have made it clear that going after terrorism financing is a high priority. And so I think this type of litigation actually serves as a real deterrent for financing terrorism against U.S. citizens. So I've taken up way too much time, but I defer to Sarah to finish us up.
Great, thanks, Ariel. We'll turn for our last panelist case before I recap briefly the two cases that our panelists aren't discussing, which that case will be argued on Wednesday, April 2nd, and Liz will tell us about Medina v. Planned Parenthood South Atlantic.
Thanks, Sarah. I know everybody's just been dying to hear about Medicaid. So yes, this next case is all about Medicaid, but it is actually quite an interesting case. In a nutshell, Planned Parenthood and an individual litigant are suing the state of South Carolina under Section 1983 over its interpretation of a provision of the Medicaid Act known as the Any Qualified Provider provision. What this provision does is it requires any state who accepts funding under Medicaid to ensure that their plans provide that a individual may, quote, may obtain medical assistance from any medical provider that is qualified to perform the service. So what this case really boils down to is whether there is a private right to sue when someone thinks that the state is violating this provision by not affording an individual the choice of their provider. So here, for background, a few years ago, the governor of South Carolina issues an executive order directing the State Department of Health and Human Services to help to hold providers of abortion as unqualified to offer family planning services. And he does so in order to remain consistent with a separate state statute that prohibits the use of public funds for abortion. So under the governor's view, the provision of any money to an abortion provider, even if it's going to something unrelated to abortion, would indirectly be funding abortions and violate that state statute. So he passes that, or he issues that executive order, and Planned Parenthood and one of its Medicaid clients then brings suit under 1983 because now this Medicaid client is saying that she's not being allowed her choice of provider. And then ensues one of a very interesting procedural path to the court. This is actually the third time this case has reached the Supreme Court, but the first time the court has granted review. So initially, the district court grants a preliminary injunction, holds there is a private right of action. The Fourth Circuit affirms both decisions. The state petitions for review from the Supreme Court, but in the interim, enough time passes that the district court has actually ruled on summary judgment for the individual and Planned Parenthood, issues a permanent injunction. So the U.S. Supreme Court denies the petition because it's basically become moot. It goes back up to the Fourth Circuit, where the Fourth Circuit once again affirms the district court's decision, again says there is a private right of action here, and the state again petitions for review of that decision. Well, while that petition's pending, the U.S. Supreme Court hears another case about when can the court infer that there is a private right of action from a federal statute. And the court then GVRs this case in order for the Fourth Circuit to consider that new decision. The Fourth Circuit reviews the new decision, says nothing changes. We still believe there's a private right of action here, affirms, and now we're back up at the court. And the court this time accepts the case. And essentially what this boils down to is the state, as I said, the statute doesn't actually say that there is a right of action here. So over the past few decades, the court has been trying to decide when do spending clause statutes, and what I mean by that is no state has to accept Medicare, obviously. So they only become subject to Medicare strictures if they, and the requirement of the any provider provision if they do accept federal funding. So over the past few decades, the court has been trying to decide when can we infer this from the statute. Some of the early cases had pretty broad language and just kind of said if we think it's about the individual, then there is a private right. But over the last kind of two main cases, including the one that the court GVR'd for, I'm going to get this name wrong, but Talevsky, both of those have been saying no. There's got to be a little bit more information in the text. One of them, they said there was nothing. In Talevsky, it was kind of if you're going to do it without the Congress saying directly there's a private cause of action, it was probably more of the clear one where it said there is a right here. It called it a right. So in this case, what the state's arguing is that the any qualified provider provision doesn't actually call it a right or use any language, any synonym for right in the statute itself. It provides other remedies for dealing with so-called violations of the statute, such as the Secretary of Health can withhold funding if he concludes a state is violating the provision. Also, South Carolina has an administrative mechanism for providers who believe they've been inappropriately labeled unqualified to challenge that status. And in this instance, Planned Parenthood, according to the state, did not actually file that administrative challenge until one day too late under their rules. So according to the state, there is no rights creating language. It needs to be very specific, like there is a right, or language kind of similar to the federal due process clause, like no person shall, or Title VII be discriminated against. That's not here, and there's these remedial provisions that take care of it. The Planned Parenthood and the individual provider say that the state is overreading the kind of narrowing this too much. The past precedent says that you're supposed to be looking to see if the statute is about the individual, if it's using language targeted to the individual. Here, the statute uses the word individual. It also says that the state must have a plan that allows the individual to select their choice of qualified provider. So they say that, and it's not conflicting with the remedial scheme, it would just be bolstering it. So that is their kind of arguments under current precedent. I think it'll be interesting to see how the justices split on this. In that last Talevsky case, you know, everybody but Justice Thomas agreed that there had been a right presented there, but everybody also agreed that it was a high bar to infer a private right. Justice Thomas dissented on the grounds that he doesn't think a spending clause, a piece of legislation that is rooted in the spending clause only, doesn't secure rights under federal law, which is what you need for 1983 action in the first place. Justice Gorsuch, who concurred, did kind of also make reference to that in a concurrence as well. So it'll be interesting to see if that comes back into play. I know we're running short on time and we have 2 more cases, so it'll be interesting to see what happens.
Thanks so much, Liz. That wraps up our panelists' cases, so I'll say a few words about the remaining pair of cases in much less depth, and then we'll turn to a little bit of audience Q&A as time allows. So if you've been hanging on to any questions, please do submit those now. This is the last call. So first up, I'll tell you a little bit about Louisiana v. Callais and Robinson v. Callais. This is a pair of mandatory jurisdiction cases that were consolidated for briefing and argument, and they both arise out of a long-running saga in which Louisiana is attempting to redraw its congressional map following the 2020 census in light of some changing demographics reflected in that census data. You may be aware that it's now 2025, so these cases have been going on for a long time. We're halfway to the next census, and the cases have gotten pretty procedurally complex, so I will not take you through all of those complexities. But briefly, Louisiana first attempted to redistrict without drawing a second majority Black congressional district. That map was challenged and invalidated in the first round of litigation, which was the Robinson case. So the Louisiana legislature went back and drew a different map that added the second majority Black district as the Robinson litigation had said it should. That second map produced the second round of litigation. The plaintiffs argued that race predominated in drawing a map with a second majority Black congressional district. So if you're keeping score at home, Louisiana has now been told by the Fifth Circuit that it's racially gerrymandering both by adding a second majority Black district and by not adding a second majority Black district, which is a little bit of a head scratcher. Louisiana's merits brief memorably concludes with a paragraph that says, quote, "Louisiana is tired," points out we're halfway to the next census. The state still hasn't been able to draw a map because the courts can't decide whether it must or must not consider race and what is an acceptable amount of race to consider. So Louisiana is making several arguments. I think the most interesting one springs from the posture of these cases, which is that the court should hold that just like partisan gerrymandering, racial gerrymandering just isn't justiciable because courts can't formulate administrable standards that states can live with, as illustrated by the conflicting decisions in these cases. So that would be the big swing for this case. Of course, the parties on the other side are arguing that the Robinson litigation didn't require Louisiana to consider race as much as it did in drawing the second map, and that race impermissibly predominated in ways that weren't required by the Robinson litigation. One last nugget on the case is that the United States filed a brief in support of neither party on December 23rd. And about a month later, on January 24th, filed a letter notifying the court that the brief no longer represents the United States' views and withdrew its motion to participate in oral argument. So this is a case where the inauguration has made a difference and an unusual redistricting case where the United States will be participating at argument. The second case will be argued a week after that on Monday, March 31st, and it's Rivers v. Guerrero, which is a Texas prisoner's habeas petition. The brief setup is that the habeas petitioner lost in district court, as many habeas petitioners do. And while on appeal, he sought leave to amend his petition in the district court. So the Court of Appeals was considering his appeal, and while that was ongoing, he asked to amend his habeas petition in the district court. An important rule of habeas litigation is that a habeas petitioner gets just one bite at the federal habeas apple, absent unusual circumstances. And those unusual circumstances have to include permission from the Court of Appeals for the petitioner to file a second or successive petition. So the question presented here is whether the attempt to amend the petition in the district court while the Court of Appeals was considering the appeal is barred as a second or successive petition or not. So the habeas petitioner argues primarily that his post-judgment filing should be treated as a motion to amend. He argues that that's procedurally permissible as part of the existing case, so it's not second or successive. Texas the lead argument from Texas on the other side is that the court should dig because of some non-merits grounds that look pretty substantial to me and may kick up quite a bit of dust at oral argument. So we may never get an answer to this fascinating and important question of whether this particular petition was second or successive. The United States also filed an amicus brief on Texas's side of the case. It obviously has an interest in habeas doctrine as well, and the U.S. will participate in arguments supporting Texas. So that wraps up all of our cases, and I'll give us just a couple of questions. So first up for Liz on the Catholic Charities case. An audience member wonders whether the Wisconsin court characterized the Catholic Charities activities as social activities or social service activities, and hopes that you can elaborate a little bit on the distinction the court made between those activities and religious activities. For example, must all religious activities be inherently or only activities that the religious engage in, like prayer or worship?
Great question. I don't remember if they use social services or social activities. I'm not sure it particularly is a distinction that matters here. I think the perfect point was more that it's an activity that someone might engage in regardless of religious belief or practice. You know, I might open a home for the elderly, one of the departments here that's being challenged, regardless of whether I'm being religiously motivated to do it. So I think in this instance, what the court was saying is that it was not something that, or an orphanage, for example, it's not something that is inherently religious or typically undertaken by religious organizations. It's a great question whether it needs to be inherently religious under the Wisconsin Supreme Court's test. Is a little confusing. The Wisconsin Supreme Court keeps insisting that it's not trying to categorize what is religious behavior, but at the same time, when it's saying things like if you are catering to the elderly, but you're not proselytizing or doing something similar to proselytizing, then you are not engaging in religious behavior. It's a little hard to see how they're not creating some sort of inherent religious test there, which I think is petitioner's point and the problem I think a lot of justices are going to be searching for at argument.
Great. And in our last 2 minutes, I'll ask the last question to Morgan. Some court watchers talk about potentially big cases with a variety of paths as largely determined by how much energy the court has at a given time. So I'm just curious if you have any comments on what the status quo is at the court these days. Are they just tied up with emergency docket cases, or do you think they have energy to take a big swing on a case like this? If you don't want to deal with that question, we'll settle for your over-under on how long the oral argument will take.
Well, both great questions. So, you know, look, the court is very busy these days. People often talk about the court's shrinking docket, and I think the shrinking merits docket is explained by the skyrocketing emergency docket that certainly makes the justices feel like they're not doing less work. I think that what they have on their emergency docket affects how many cases they take, and maybe the appetite for that. I don't think that it has a strong effect on what they're going to do in those cases, and in particular with non-delegation. I don't think the fact that they may be feeling busy is going to decide whether they choose path 1, 2, 3, 3A to D. I think what's going to be really driving that is where people can coalesce with all of these different considerations coming into play. And I think argument will be actually quite helpful for this case in ways that it's maybe not determinative in many other cases. As for how long it'll go, you know, I do think that the chief has pulled back since the affirmative action arguments. So I don't think that we'll get too crazy on this one. So I'll give you hour 50. I'll set the over under there.
Perfect. Good. Well, thanks so much to all of our panels. Thanks to all of our panelists. Thanks so much to the Federalist Society for putting on this program and all the other Seat at the Sitting programs. And with that, I'll throw back to Nate to wrap us up.
Thank you, Sarah. Thank you to you for moderating so well, and also to all of our panelists. Absolutely fantastic as advertised. We look forward to having each of you back with us again very soon. For our audience, if you have feedback on this program or any others from the Federalist Society, we'd be delighted to have it at info@fedsoc.org. And with that, until next time, we are adjourned.